our 9 a.m. docket, and that is Dawson Trust versus Schwartz. And then we have one other case set this morning, and that is Marriage of Guthrie, which will follow this argument. And so it looks like counsel are at table on Dawson versus Schwartz, and each side will have 15 minutes for your argument. There is a lighting system on the podium. When it turns to yellow, it means you have 5 minutes remaining. When it turns red, it means your time is up. The appellant may reserve time for rebuttal if you wish. And if there's no questions, you may go ahead and begin.
Good morning. May it please the court, my name is Rick Ruffner. I represent the Lonnie W. Dawson Trust. The case before the court this morning has its genesis in October of 2012, when Gabriel Schwartz was appointed as the new trustee, replacement trustee of the Lonnie W. Dawson Trust. Contemporaneously with that appointment, the previous trustee funded the corpus of the trust with a $1 million deposit. What was not known for almost 3 years was that 8 days after that appointment, Mr. Schwartz withdrew $435,000 of that corpus and purchased a mountain ski property in Avon, Colorado. As I said, that was not known until the middle part of 2015. At no time did Mr. Schwartz, as trustee, file any annual reports reporting to the court with regard to the assets, its expenditures, or anything else. So that remained hidden. In July of 2015, through certain circumstances, it was discovered that there may be money not in the trust as thought. An investigation was undertaken, and it was learned at that time through a private investigator that the $435,000 had been spent on that condominium. What was also learned is 16 months after that, Mr. Schwartz quit-claimed that property to his own personal name, again without any reports to the trust or to the court. That became the genesis then of the pleadings filed by the beneficiary of the trust in July of 2015, both to implement the court's supervisory powers over the trustee, as well as to bring claims for the wrongful taking and withholding of property and damage caused to the trust. That proceeded to trial in 2017, ultimately with a judgment in the favor of the trust with offsets in the favor of the trust and against Mr. Schwartz. The primary issue here today is whether that judgment, which was based upon the wrongful taking and withholding of the property, should be entitled to an award of interest until paid back. And if we have set forth in our brief, we say the answer to that question is yes.
So, Mr. Ruffner, what I understand is you have two statutes that may apply, and one is the surcharge statute that does have a provision that a court may award interest, and then you have the statutory interest statute, the more general statute that requires the statutory interest for prejudgment interest. So tell me why the more general statute should trump over the more specific.
Certainly. First of all, the probate statute, which you're referring to, that has the may language in it, is simply supervisory. That's what the court uses to administer the trust and to make sure the trustee is properly performing within the auspices not only of the court's order of appointment, but also the probate statute. 512-102 is a specific statute for the wrongful taking of property. There is nothing in the probate court, or excuse me, in the probate code with regard to that provision that says no other statute may apply to a trustee's wrongful conduct. Indeed, I point to cases which the appellee submitted to this court just last week in supplemental authority. and that's the Taylor case. The Taylor case very clearly illustrates what I'm talking about. In Taylor, there was a tort action brought by interested parties, as well as a supervisory action under the probate code. The proceedings were consolidated, and it proceeded under the probate court's supervisory powers and statute, but the tort claim was also considered. In Taylor, the court did not say those statutes were mutually exclusively, quite the opposite. Matter of fact, although the holding was in reverse, with regard to the application of 512-102 and attorney's fees, it said because the action was under 512-102, the remedies available in the probate code did not apply. It certainly is implicit, and I state it's explicit in Taylor, that the remedies available in other statutes, in common law, or whatever, are certainly available.
What do you do with the Barron decision from the Colorado Supreme Court, which appeared to, which declined to award prejudgment interest pursuant to 512-102 because this case is not a contract or property damage case, it's a probate case?
I say this is a property damage case. This is a wrongful taking of money.
This is not a probate case then?
No, not for that particular issue. It's a wrongful taking of money. It caused harm. You have a victim from the taking of that money. And the purpose of the interest statute is to make the victim whole. Here, there's no way to make the victim whole unless prejudgment interest or some other form of prejudgment compensation is awarded. That's the whole purpose of the interest statute. In this case, we have the trustee, Mr. Schwartz, holding on to the property from October 2012 until he finally paid the satisfaction of judgment in 2017. During that time, there's an appreciation of real estate that goes to his benefit, not to the trust. There were no rents paid over to the trust when it was still in the trust name for 16 months. There was absolutely nothing to make the trust whole within the court's order in the lower court.
But you brought the action as a probate action, right, under the trust provision of it?
Both. It's within the probate code. So we brought the action both with supervisory questions as well as the wrongful conduct questions. The supervisory is because we were dealing with a trustee. We asked for the trustee to be removed because of the misconduct. That clearly brings it within the probate code. That was procedurally what was done. Within the action filed in July of 2015, we also asserted the wrongdoing which caused damage to the trust.
Well, Mr. Ruffner, when the action was brought, it was brought as a surcharge action under the surcharge statute. And I read through that, and I didn't see any reference to any specific tort claim separate from that, or when there's a request for interest, the request was still under the probate statute. So did the court have any idea that you were bringing a separate tort claim?
They sure did. Within that pleading in July of 2015, the wrongful conduct is alleged. More importantly, in the pretrial statements, the trial management certificates, as well as the arguments made to the court, written arguments to the court, we're again making a claim under 512-102 for the interest. That's all within those pleadings prior to the trial. The closing argument was at the close of trial, but the other pleadings were clearly there ahead of time. So the court was certainly alerted to it as we proceeded on both tracks, if you will, supervisory sanctions, including termination, although Mr. Schwartz did resign, as well as then the wrongful conduct claims for damage as caused to the trust. And I would also assert, Your Honor, in response to your question, it would make no sense for someone to do a wrongful act that deprives a person or entity of property and not be subject to interest just because one wears the title of trustee. Someone else not wearing that title of trustee with same or similar conduct would be clearly subject to the mandatory interest language of 512-102. It would make no sense in this case simply because a person has the title of trustee to escape what other citizens might suffer as a result of their conduct.
And yet, the surcharge statute specifically refers to interest. It says, such damages may include compensatory damages, interest, and attorney's fees and costs.
Yeah.
I mean, are you asking us to ignore the interest language in that statute?
No, I'm saying that statute, the only difference between that is it's a may statute. The court, within its discretion under the probate code, may award interest, may award attorney's fees, or such other relief as it deems appropriate. 512-102 is a mandatory interest statute. And that's all I'm saying, that mandatory language would trump the discretionary language in the probate code.
Okay.
Well, why would the legislature use two different, a may or mandatory?
I'm sorry, Your Honor.
Why would the legislature include different language?
One's a supervisory statute
Well,
of a
then why
probate.
may? If it's still a wrongful taking, it's a breach?
The probate code doesn't refer to wrongful taking,
Okay, but that's the essence of your claim.
right? And so therefore, the 512-102 standard, which does pertain to wrongful taking, would apply. Because there's nothing within the supervisory powers that would call for that.
Well, the court has, the trial court has discretion with the may language,
Right.
does it not?
It does if it's entering sanctions pursuant to the probate code. That is discretionary with the court in fashioning its remedy. When the court also, as in Taylor, when the trier of fact also considered the tort claim, then the tort statute comes into play. 512-102 comes into play, and that's within the Taylor case. The court was there both in its supervisory role, and then there also was a trier of fact of the tort claim within the same proceeding. And
But your claim was brought under the probate code in a supervisory, challenging the supervisory role, was it not?
we asserted that the court had jurisdiction and venue to consider the matter, but we still alleged.
Based on the probate code?
Yes, that's correct. But it also has concurrent jurisdiction, as I believe the Taylor case shows, to consider the tort claim as well.
Well, let me ask you this, if you don't mind my.
I'm sorry?
Let me ask you this.
Sure.
Could you have added a claim, a tort claim, like they did in the Taylor case? Could you have had two separate claims in this action?
I believe we had it within our original petition, that we had the parallel claims. We have a claim for damages. We also have a claim for the court to exercise its supervisory powers to terminate the trustee and do whatever else, perhaps order an accounting or whatever needed to be done. But we had it. There were parallel claims.
Did you have a specifically identified fraud claim or anything along those lines?
Just a wrongful taking, of property
Okay.
without authority
Okay.
is what we had. Briefly, let me address the defamation claim, which we've also appealed, and the damages issue. The court made a finding of defamation per se based upon the trustee's letter to the 7 contingent beneficiaries. We're not contesting the finding of defamation. What we're talking about is causation of damages, and in particular, the trial court's looking at the purported damage suffered by Mr. Schwartz with family and friends. But again, there's absolutely no evidence that the publication of the one defamatory letter by the trustee ever went to family and friends. And therefore, there can't be any causation of those types of damages which the court awarded. Absent causation, you can't make that award of damages. And so we're asking that the matter be remanded for the court to look at the damages that could have been caused or would have been caused by the defamation.
I was just pointing out to Judge Lichtenstein that you have 1:17 left. It didn't go amber light, so I'm not sure
It
if
did
you're
not?
aware of that.
I'm sorry. I'll reserve if I might at this point. Thank you, Your Honor. Thank you very much.
Thank you.
Good morning. May it please the court, my name is Jared Ellis, registration number 36834, and I represent the appellee, Gabriel Schwartz. This case is really, aside from all the factual detail provided at the beginning of my opponent's argument, about the trust's dissatisfaction with the surcharge award entered by the probate court. That dissatisfaction does not provide a basis for reversing any of the court's rulings, much less the ruling on interest or the ruling on damages.
Let me stop you just for 1 second. Can you reset the clock, please? Thank you. We are having a lighting issue. Sorry, it's not you. Okay, we're ready to go.
Thank you. I'm going to address two issues. First of all, I'm going to address, well, and perhaps a third if I have time. The first issue is obviously the issue of the district court's refusal to award interest under the surcharge statute. The second issue is the sufficiency of the evidence regarding the award for defamation damages. And finally, if I have time, I'd like to explain why the court should award appellate attorney fees to Mr. Schwartz. Turning first to the issue of interest, Mr. Ruffner argues that the court erred because it failed to apply CRS section 512.102, which is, as the court pointed out, the general statute providing for awards of prejudgment interest in contract and property damage cases. I think there are at least three reasons that the court correctly declined to apply that statute. The first is that, as has been pointed out, the trust chose to bring its claims under the surcharge statute, CRS 1510-5042. And the surcharge statute contains specific language pertaining to awards of interest. That language says that the court may surcharge the fiduciary for damage or loss to the estate, and such damages may include compensatory damages, interest, attorney fees, and costs. The discretionary language of the surcharge statute essentially allows a court great discretion in crafting an appropriate remedy based upon the circumstances. And that remedy may or may not include interest as the court sees fit. In
Mr.
fact, that's
Ellis,
the...
Sorry to interrupt.
Yeah.
Would you disagree then with what Mr. Ruffner just characterized, that there was a parallel claim, tort claim for wrongful taking?
I would, Your Honor, and I'm going to point you to a few points of the record where I think that that'll be relatively clear. In the trust's response to Mr. Schwartz's motion to strike, the trust said as follows: "This matter is a probate matter in which the trust asked the court for an exercise of its supervisory powers to assess surcharges against Mr. Schwartz." And then it went on to say, "This case was not a civil lawsuit seeking damages." That's at the record, page 1079, the court file. In addition, in its motion for surcharge, the trust stated that it was seeking an order surcharging the trustee for compensatory damages pursuant to CRS 1510-5042. There's absolutely no mention of a parallel tort claim in the motion for surcharge. And finally, in the trust's written closing argument, it stated, "The Lonnie W. Dawson Trust has asserted a claim for surcharges against its former trustee, Gabriel Schwartz, appointed by the court on October 3rd, 2012 as trustee of the trust, pursuant to CRS 1510-504. Again, no mention of tort claims. So the way that this claim was pled was as a surcharge claim. There was no separate tort claim pled. It wasn't mentioned in any of the pleadings. And the reason that I think that's significant, and I think, Your Honor, you mentioned whether or not the court had notice of the possibility that this tort claim existed. If you look at the Taylor case, which is one of the cases we cited in our supplemental authority, what that case says is that essentially a surcharge action under 1510-504 is not equivalent to a tort remedy. So saying I'm claiming a surcharge damage under 1510-504 does not alert the court that there's a separate civil tort claim for breach of fiduciary duty. And that's why we believe that there was not a separate tort claim pled, and that the argument that for some reason this separate tort claim entitles the trust to damages or to interest under 512.102 is incorrect.
Let me ask you this. What's the real difference between a wrongful taking and a determination by the trial court that the fiduciary has acted improperly in the removal of the money?
Well, first of all, I think it's difficult to answer that question because I'm not aware of a tort of wrongful taking. There is a tort of conversion, but I think the primary distinction would be that under the surcharge statute, there are specific remedies for specific conduct. There has to be a breach of fiduciary duty by the fiduciary. A wrongful taking claim, I'm not sure requires any proof of breach of fiduciary duty. To be honest with you, I'm not sure what the elements even are. And so I think that the significance is that by invoking that specific statutory remedy under the surcharge statute, the trust is limited to the remedies that are provided by that statute. For example, Mr. Schwartz couldn't have a jury trial because the surcharge statute specifically says that you're only entitled to a hearing in front of a court. And so by invoking that remedy, Mr. Schwartz wasn't entitled to have his defenses heard by a jury. The same is true for the trust, though, because by invoking that remedy, the trust invokes the discretionary language pertaining to interest, which means that if it argues that it should have interest and the probate court disagrees, that it's stuck with the probate court's ruling.
Well,
And
then,
so,
sorry to interrupt again. Why the discretionary language on interest?
well, I think primarily the probate code is kind of designed to allow the court to exercise equitable discretion. And so I think what the underlying intent of the statute was is that in these types of cases, the court may want to award interest. It may want to award interest at a specific rate that's different than a statutory rate. It may not want to award interest at all. And I think that the way that we can kind of trace that development in the law is that there was a pre-existing common law rule before the surcharge statute was adopted. And under the pre-existing common law rule, essentially courts had unfettered discretion to award interest, to not award interest, to decide the interest rate. So I think that the kind of thought process here is that it may or may not be appropriate to award interest depending upon the circumstances.
Well, it sounds like this would be an unfettered discretion. What is there to review the trial court's decision or the probate court's decision to award or not award interest?
Well, I think that it goes back to the general standard for abuse of discretion. So as long as the probate court's award isn't manifestly arbitrary, unreasonable, or unfair, then that would be sufficient to sustain its decision. And in this case, the probate court declined to award interest for two reasons. First, it found that under the trust agreement, the trustee could essentially loan money with no interest, and so it found that an award of interest on the funds would be inappropriate. But second, the probate court found that an award of interest under the circumstances would create a windfall to the trust disproportionate to its losses. And I think that there are a few pieces of evidence that really support that finding. One of them is that we asked questions of the current trustee about what the interest rate was for funds in banks for investments that the trust had. And the current trustee couldn't point to anything at 5%. The only thing that he could point to was the FDIC rate at 1%. And so when you're looking at the interest rate under 512-102, which is 8%, it's a significant interest rate. The court was obviously concerned that the trust's investments, had they been invested in a way that was normal or typical or different, would not have earned that 8% interest. And I think it's also important to keep in mind that the trust had the option to put on evidence as to what a reasonable rate of return would have been on this money had it been invested differently. And it chose not to put on that evidence. There was no evidence presented of what the interest rate for this money would have been. There was no evidence. You heard Mr. Ruffner talk to you about rental income. There was no evidence presented at trial as to what the rental income for the property would have been. And so I think in light of those findings, which are supported by the record, this court really can't say that the district court's ruling was manifestly arbitrary, unreasonable, or unfair. It considered the argument that was presented by the trust. It considered the trust request for interest and made a reasoned decision considering all of the circumstances, balancing the equities, and considering the evidence.
Mr. Ellis, let me ask you more a statutory question. So Mr. Ruffner had argued that because the surcharge statute is merely supervisory, that's another reason why we should give, we should have the statutory interest statute trump over the surcharge statute. Could you respond to that argument?
Absolutely, Your Honor. I don't know what that really means, supervisory, but what I can tell you is that the Taylor case, which Mr. Ruffner discussed at some length, I think is very helpful on this question. And the reason is, what the Taylor case says is that in adopting the probate code, the General Assembly intended to specifically regulate particular types of persons in transactions. It intended to regulate fiduciaries and probate issues. And it intended to displace other regulatory schemes, including those schemes that apply to, for example, torts or contracts. And so what I think that suggests is that the specific language in the probate code that authorizes an award of interest in the discretion of the court in surcharge actions does displace the language of other provisions, including 512-102. And that's exactly what the Supreme Court held in the Barron case, which, flat out says that the 512-102 does not apply in probate cases. The reason for that is because the probate code is intended to be the exclusive source of regulations for those cases.
Let me follow up on the Barron case, because I think that case was addressing whether someone was entitled to money as a beneficiary, and there was no allegation that anyone was wrongfully withholding money. So is it distinguishable on that point, and why not? Why or why not?
Certainly the facts are different, but the legal language in the Barron case, it simply states that 512-102 does not apply in probate cases. And I don't think that the court can really distinguish based on the facts around that language. This court is obviously required to follow the rulings of the Supreme Court. And so while I think the facts might be arguably different, that point of law I don't think is different, and I don't think can be avoided on those grounds.
Let me ask you the same question I asked Mr. Ruffner. Having started this proceeding under the Probate Act and the surcharge provision, could he have added a claim for tortious conversion or fraud or something along those lines? Or once you start within this provision of probate and trusts, are you then stuck with its remedies, or can you add additional claims outside of that?
I think the answer is that you can add claims if you choose to do them. And I'm not sure whether those claims are properly in front of the probate court or whether they would need to be brought in a separate court that has general jurisdiction over civil cases. But the important thing is that in this case, that never happened. In this case, the trust proceeded with its surcharge claims under Section 1510-504 and never chose to add a claim, to file a complaint, a civil complaint with a claim for conversion or fraud or any other sort of a civil claim. Essentially, the only claim we were ever on notice of is the claim for surcharge, and that's the only claim that the court was ever on notice of. And so certainly under those circumstances where the parties proceed as though there's only one claim and there's no notice of a separate civil claim, the exclusive remedy, I think, must be the surcharge statute.
Mr. Ellis, I'm just going to alert you our clock again is not turning yellow when it should have, so you have 3 minutes remaining.
Thank you very much, Your Honor. I'd like to turn briefly to the issue with respect to sufficiency of the evidence. I think there are a couple of things that the court needs to keep in mind when reviewing the sufficiency of the evidence, but the main one is that the standard of review is clear error, which is one of the most difficult standards to overcome. This court is essentially bound by the probate court's factual findings unless there's no evidence in the record that supports those findings. And I think it's also important to keep in mind that the trier of fact and not the appellate court is responsible for determining the weight and credibility of the evidence. With respect to the issue of damages on the defamation claim, the court awarded $70,000 on the defamation claim. It did so based on a determination that the statements were defamatory per se. We think that the court need not even look past that issue to affirm the damage award, because once there's a determination that a defamatory statement is defamatory per se, all that is required to recover damages is to prove that there was a defamatory statement and that it was published. In fact, the pattern jury instruction on defamation per se involving non-public figure defendants, non-public figure plaintiffs, says those are essentially the only two elements. All you have to prove is publication of a defamatory statement. So we weren't required to put on evidence that this publication of this letter caused damages to Mr. Schwartz.
Well, would it be germane to the amount of damages?
It certainly could, Your Honor. And I think that it's important in that respect to keep in mind that the probate court, as finder of fact, had exclusive province over the amount of damages. But we did put on evidence that supported the amount that it awarded. For example, the probate court made findings that damages were appropriate because the letter caused Mr. Schwartz some financial loss, personal hardship, and reputational harm. Mr. Schwartz testified that the letter caused him financial hardship. In particular, it caused him to lose existing clients, and it diverted his time and efforts from paying clients. Mr. Schwartz testified that the letter caused him personal hardship because the allegations in the letter stressed him out to the point where he could no longer sleep, and he was diagnosed with anxiety. And there was evidence that supported the finding that it caused reputational harm because the evidence indicated that one of the recipients was an attorney who was a professional colleague of Mr. Schwartz. And certainly, Mr. Schwartz testified that the allegations in the letter made him appear as though he was a thief. I did want to turn briefly to the attorney fees issue. The trust has argued that we're not entitled to attorney fees under a provision of the code 1510-6054 that essentially limits a fiduciary who's unsuccessful from recovering fees or costs of that defense. We aren't seeking fees or costs of that defense. We're only seeking attorney fees on appeal. Thank you very much, and we'd ask that you affirm.
Thank you.
I'm a little confused on my time. Could I have a clarification?
Okay, right now you've got about a minute remaining, but let's make it a minute and a half because I think that we added some time to Mr.
Okay,
Ellis.
I was just
Okay.
confused by the lights and so on.
Yeah, I
so-
understand. So you will have a minute and a half starting now. Okay.
In addition to the numerous pleadings which are in the record regarding responses to various motions for summary judgment in which we set out the wrongful conduct time and time and time again, to show that this case was proceeding on two parallel paths, both supervisory, which the court can initiate sua sponte on its own, and on a tort claim, is the very fact that Mr. Schwartz filed a counterclaim in tort for defamation. So we're proceeding down the tort wrongful taking of property path. We're proceeding down the supervisory. What could be clearer that we had two different paths in this case with 512-102 pertaining to the various tort claims and wrongful conduct claims of both parties, and we have the court's supervisory powers as it relates to the administration of the trust. The Barron case was a supervisory case. It had to do with the equitable relief that a probate court could enter as part of its supervision of the trustee. It had nothing to do with wrongful conduct. And yes, the Barron's case said 512-102 doesn't pertain to misbehavior by a trustee with regard to conduct in the probate code or under the provisions of the trust. It said nothing about that there couldn't also be a parallel case against a trustee.
Okay, thank you, Mr. Ruffner. Now your
Thank you.
time is up.
Thank you.
Thank you both, counsel, for your very helpful arguments. The case will now stand submitted, and we will be issuing an opinion in due course. Thank you. All right, so just to clarify, we have the Marriage of Guthrie case, and did you have that it starts at 9:30 or 10? 9:30, thank you very much, okay. We had two different sheets here. All right, so counsel for Marriage of Guthrie can start setting up when the other counsel has left the courtroom. All right, we will be calling the case of Marriage versus Guthrie. If counsel were not in the courtroom when we were making our preliminary announcements before, each side has 15 minutes to argue. If our clock system is working at 5 minutes, the light will turn to yellow, and when your time is up, the light will turn red. The appellant may reserve time for rebuttal if you wish, and we'll I'll try to keep track of the time. And if anyone here has a cell phone or something that makes noise, be sure to turn them off so we don't interrupt the arguments. And we are ready to begin.
Good morning, Your Honors. May it please the Court. My name is Charlene Aiken. I represent Michael Guthrie, who's the respondent appellate in this case, and I will refer to him as husband. This court has issued 2 written questions I'd like to address, and the first question was, given the procedural posture of the case and that there are 2 motions pending in the trial court, specifically a motion to modify and reconsideration, what issues are properly before this court. And I think that in order to understand that question, we need to look at the procedural posture of the reconsideration motion and the motion to modify. This trial court issued its ruling on appellant's motion to terminate or modify maintenance on February 28, 2017. There was judgment entered against husband. This was a final and appealable order. Any appeal was due by April 18, 2017. An appeal was filed April 11, 2017. On March 27th, husband's prior counsel filed a motion to reconsider the order, and she failed to provide any legal authority. I believe that this motion was filed outside of the jurisdiction of Rule 59, and that the failure to file this motion within that time or file an extension allotting for more time, the trial court lost its jurisdiction to act under that motion. A response, however, was filed on April 11, 2007 by wife's counsel. So the reconsideration motion was filed before perfecting the appeal, but after the trial court had lost jurisdiction. So after the appeal was filed, and as this court knows, once an appeal is filed with the trial court or with an appellate court, a trial court is without jurisdiction to enter any orders enlarging, diminishing, or changing the rights unless absent an order of remand. So following the appeal, I filed a motion for a limited remand on May 8, 2017, asking to revert jurisdiction back to the trial court to reconsider to hear the reconsideration motion. It was fully briefed, including a reply brief, and it was denied by Chief Justice Loeb on June 19, 2017. So as to the motion to modify, that was filed on May 29, 2015 in the trial court. There was an ex parte hearing January 11, 2017. The order ruling on that motion was February 28, 2017. On that same day, there was a new motion to modify filed in the trial court that has since been held in abeyance until resolution of the appeal, and I found that through the e-filing system. That was a February 28, 2018 order. So I believe that the issues properly before this court are husband's 2015 motion to terminate and modify maintenance and the trial court's dismissal of that on January 11, 2017. And the issues related to the motion to modify are the continuance of the January 11, 2017 hearing, husband's VA disability pay, and the burden under that modification motion. Before I address those things particular to the motion, I would like to address this court's second question, which is dealing with the legal authority upon which the trial court has awarded attorney's fees to wife and what specific findings of that determination. As this court is aware, attorney's fees in a dissolution case can be awarded under either 1410-119, 1317-102. Those statutes are not mutually exclusive. 1410-119 is based upon the relative economic circumstances of the parties in order to equalize their status and to ensure that they do not suffer undue economic hardship. But the trial court must consider the relative financial status of each party and must make findings regarding their incomes and their assets and their liabilities. And it must explain how and why it arrived at the specific amount of the award. Versus 1317-102, which is more of a sanction, and which means that the claim or defense is substantially frivolous, groundless, or vexatious. And still, the trial court must make findings explaining why the conduct lacks substantial justification, discuss how the court arrived at the dollar amount. So let's look at the record here. Wife's request for attorney's fees. She made no request in her response to the motion to modify. She did not file a separate motion for attorney's fees. And at the January 11th, 2017 ex parte hearing, she had almost forgot to request attorney's fees until she was prompted by the district court. And the court then stated, especially in light of the fact that it was his motion, so wife had to expend attorney's fees to defend the motion, and then he doesn't show up for the hearing, I will award attorney's fees. So if you'll file an affidavit of attorney's fees in proposed order. That's in the record at page 4, line 45 to page 5, line 51.
Counsel, sorry to interrupt, but could that be an implicit finding of a sanction?
Yes, Your Honor. And actually, getting further, wife's answer brief actually argues that because the litigation was prosecuted by husband in bad faith or it was vexatious, that could be construed as that the attorney's fees were awarded pursuant to 13-17-102. If that is the case, the district court findings are insufficient and such award cannot stand, because the district court here was required to make findings explaining why the conduct lacks sufficient or substantial justification, discuss how it came up with that dollar amount. Conclusory statements are not sufficient for appellate review. And in addition, because husband was pro se under 13-17-1026, there's that additional finding that the trial court must make to show that the party clearly knew or reasonably should have known that his actions was substantially frivolous, groundless, or vexatious. The order granting wife's attorney's fees in the full amount did not make any findings, did not make this heightening finding as to whether husband clearly knew or reasonably should have known. And the district court simply stated it was awarding attorney's fees to wife due to husband's absence and wife's defense of them. In addition, there's no reasonableness and necessity of the fees, which I believe is also required under the statute. And in particular, under 119, if this court can construe the attorney's fees under 119, you must present it at the time of the hearing, and wife did not testify as to the reasonableness and necessity. Wife's affidavit failed to make a claim that such fees requested are reasonable and necessary. She didn't even include a billing rate in her affidavit. The order lacks any findings that the attorney's fees were reasonable and necessary. And in fact, when wife submitted her affidavit and her proposed order on February 10th, 2017, at the record 263 to 87, husband was pro se at the time, and she didn't even serve husband with a copy of the proposed order and the affidavit. So under CRCP 121, he couldn't have made an objection to the attorney's fees or requested his mandatory hearing if he had chose to dispute the reasonableness and necessities of the attorney's fees. And
Ms. Aiken, let me, sorry to interrupt, I wanted to move back in time a little bit.
Sure,
Something I was curious about. January 5th,
right.
apparently the judge had to reschedule that.
Yeah,
That
due to
record's
some
not real
family
clear.
emergency.
Okay. Your client knew about that hearing.
Correct,
He wasn't in court at that point.
right,
Okay, now we go about a week later
right,
to January 11th.
right.
The thing that your client appears to have known about that hearing very clearly since he made a phone call that morning.
Several phone calls.
Right.
Yes.
From some distance away. My
Right.
question has to do with, your client was pretty far away from court, a state
Correct.
away at
Correct,
the time that a hearing was scheduled.
correct.
So if a court wants to sanction or impose attorney fees, that seems, I mean, it seems like your client, pro se or not, walked away from a motion and didn't appear at a hearing that was scheduled that he knew about.
Your Honor, he was also away during the January 5th hearing. I believe he was, even if the hearing would have taken place on January 5th, I believe that he wouldn't have been able to come because he was in need of his bipolar medicine. So I don't know that the time frame of the January 5th to 11th and knowing about the two hearings really makes a difference here.
Well, he's a day's drive away, perhaps?
Right, but then there was the snowstorm that prevented him from driving to court on January 11th, and also the need for his bipolar medication and unable to get behind a vehicle.
Was that stated? He couldn't drive because he didn't have medicine?
So, Your Honor, as far as his continuance, and I will go into those records, so he made 2 phone calls to the district court before the hearing took place, and he made phone calls in the morning of the hearing. He also submitted,
In the morning of the 11th?
yes, the morning of the 11th. The night before, he submitted an email to the division clerk letting her know he didn't have his medicine, that he wanted a continuance, that he was stranded, he was unable to get there. He also submitted what's called an ADA request for a continuance due to his mental health illness. I don't know how those ADA requests get to the division. And also, he did talk with the division clerk the morning before the hearing. He told the division clerk exactly what was going on, that he was stranded, he was unable to get his bipolar medicine, and she told him that the judge will be making a ruling and he will get notice by mail. So I think under the law of a continuance and good cause is usually shown by unforeseen and exceptional circumstances. I think this is the textbook case of unforeseen and exceptional circumstances. I mean, it wasn't foreseen that he would be stranded by a snowstorm or that the court would continue the January 5th hearing. And
So, Ms. Aiken, staying on the continuance issue,
sure,
so the phone call to the clerk, it's in the record?
Yes.
Occurred before the January 11th hearing started at 9:11 a.m.?
yes, so there's one phone call at 6:58 a.m., there's one for 2 minutes, there's one at 7:11 a.m. to the division for 2 minutes. There was also phone calls before the hearing as well. And
The
then there's,
conversation with the clerk occurred as part of one of those times that you just gave me?
yeah, that's reflected in an order, a minute order, and I believe that's at page 261. And that minute order is time-stamped 8:14 a.m. The hearing commenced at 9:12 a.m.
And do we have any information in the record that the trial court was aware of that conversation or of any of the other attempts to call the court before the hearing started at 9:11?
The hearing transcript is very limited, and I think the court's just saying, because husband isn't here, I've started this 15 minutes later, and I'm apt to just dismiss this motion. So I don't know that the record actually reveals whether those telephone calls and conversation with the clerk were actually transferred to the judge's knowledge. But nevertheless, as far as getting back to Judge Furman's question and whether the attorney's fees were awarded as part of a sanction for not showing up, that is a probable case, even though the statute wasn't cited. But even then, there isn't the mandatory and statutory factors that are required under that statute, which have been cited on page 21 and 22 of my brief.
But I want to stay on the continuance for just a second.
Okay.
I'm sorry.
That's okay.
So if the court didn't have a motion for continuance in front of it and was not aware of these efforts to reach it ahead of time, how is that an abuse of discretion for the court to decide to deny? Well, there was no motion for continuance in front of it, so how did it abuse its discretion?
You're right, there was no written motion for continuance from husband, but I think given the circumstances here that hopefully we can construe what his actions and conduct were as a motion for continuance, given that he was pro se. I know the rules aren't supposed to be laxed for pro se parties, and also given the fact that the court did recontinue its January 5th hearing. So I think it still abused its discretion in not considering the fact that all these efforts were made. Unfortunately, I think if it had the chance to rule on a reconsideration motion, maybe that, ruling could have turned the other way, but unfortunately, the court did not get to because it was filed out of time. I'd like to reserve my remaining time for rebuttal.
Okay, thank you.
Thank you.
May it please the court, my name is Dan West. My bar number is 27573. I represent the petitioner appellee in this case, who's now known as Molly Jo Brislin, formerly known as Miss Guthrie. I too want to, as counsel did, I'll address the respondent, my client as wife, and the appellant as husband, or as husband as well. And the first one, I'll address the court's July 3rd, 2018 order that were some questions that the court wanted answered as part of oral argument. And the first question is, given the procedural posture of this case, that there are two motions pending before the trial court, a motion to modify, a subsequent motion to modify, and a motion to reconsider, what issues are properly before this court? And I think to address first the motion to reconsider. The motion to reconsider, I believe, is controlled by Molitor versus Anderson, which I cited in a footnote of my answer brief. And I would suggest, had the trial court actually ruled on the motion to reconsider that was filed, that it would have violated that Supreme Court precedent of Molitor. The factual issues are a bit different between Molitor in this case, in that Molitor, the motion for reconsideration was actually filed after the notice of appeal was filed. And in this case, the motion to reconsider was filed before the notice of appeal was filed. But the distinction, I don't think, has much relevance. The issue, as described by the Supreme Court in Molitor, was whether after an appeal has been perfected, does the trial court retain jurisdiction to consider a Rule 60 motion and deny that motion. And the holding is, in this jurisdiction, a trial court may not determine matters affecting the substance of a judgment once an appeal of that judgment has been perfected, unless an appellate court issues an order remanding the judgment to the trial court. And in this case, the appellant, the husband, filed a motion for limited remand. I argued that the new motion to reconsider that would be filed, as husband argued, was really just a Rule 59 motion and really shouldn't be remanded. The court didn't indicate why it was denying it, but it did deny that motion for remand. And so in absence of a limited remand, this court has jurisdiction on the issues that were raised here. The motion to modify maintenance, I don't think there's a lot of good case law, but as I understand what the trial court is doing and looking at the e-filing system, is they're holding that motion in abeyance, waiting for this court to rule. And I would suggest that that's probably the right thing to do. But certainly by filing a motion to modify maintenance, the motion to modify maintenance before the trial court doesn't prevent this court from ruling on the issues raised. Briefly, the second issue is what's the legal authority relied on by the trial court for awarding attorney's fees, and what specific findings support that determination. I agree with counsel. I think that this is either a Title 14 or a Title 13 award of attorney's fees. I think the trial court should have made some more findings. That would have been the better practice, no question. I think the court was entering this as a sanction, and that's on page 4 of the transcript of the January 11th, 2017 hearing, where the court says, well, he filed this motion, he didn't show up, I'm going to award attorney's fees. I think the trial court had discretion to do that under Title 13. And again, I don't, obviously you wouldn't have asked that question if it was very clear in the record. It's just not. It would have been a better practice if the court said, I am going to award attorney's fees under 17C A0617, tell the, explain the reasonings for that, but I don't think that that's reason to overturn the trial court.
Well, let me ask you this, because husband was pro se at the time, and there are additional findings that must be made for a pro se party. So is the record sufficient on that ground?
I think it is, Your Honor, because I think that I understand that subsection 6 of 13-17-102 does talk about those additional factors. In fact, I was just reading it as you were asking counsel about those questions. I think the court should have made those findings, but I don't think that in the absence of making those findings, that you have to overturn the trial court. Certainly, I think there's an argument to be made that maybe it should be remanded to the trial court to make those findings and to see what reasonings were that. Obviously, my position is that the trial court should be affirmed, that there's no reason to do that, but I could understand where an appellate court might look at that. Hey, let's remand it and see why this trial court did that.
Well, Mr. West, sorry to interrupt.
Nope.
My question is similar to what I was asking Ms. Aiken. There's no question that on the 11th, husband telephoned the clerk a few times. He was not around the week before at that scheduled hearing, correct?
That's correct.
And he's not around now. He's quite some distance from the court.
Correct.
Do you know if the judge was aware of the phone calls made earlier, apparently before the hearing?
I do not, Your Honor. And if you read the transcript, it would appear that the trial judge was not aware of those.
Well, I did read it, and that's the impression,
Right,
but the
but we don't
judge
know.
doesn't address it one way or the other.
I agree. You cannot tell whether the judge was aware of it or not. But I think I think the important point there is there was a January 5th hearing that the husband did not show up for. Then there's the January 11th hearing that the husband does not show up for, making the same claims for continuance on both the 5th and the 11th. Essentially, they are a little bit different. But what did he do between January 5th and January 10th? And it was late at night on January 10th, this is the first time he calls. He doesn't do anything during that time period. And that's why, and that kind of goes into the substantive issues on the actual briefs. But to answer your question, Your Honor, I don't think you can tell from the transcript. The court certainly doesn't mention it. I haven't looked at that page of the transcript that was referenced by counsel. I had recalled that the calls were after hours, both on the evening of the 10th and the morning of the 11th. But if there is a minute order that says that there was that conversation at 8 something in the morning, it is what it is. I just didn't recall that. Addressing the first issue in appellant's brief, I think is really more of 3 issues. The issue is, did the trial court err in dismissing the motion to modify maintenance? And I think that there's 3 issues that can be addressed in that. Did the court err, abuse of discretion, in dismissing the motion? Did the court err, abuse its discretion in denying a continuance? And the third is the VA disability benefits issue. With respect to the motion to modify maintenance, the argument is made that there was insufficient evidence for the court to dismiss the motion to modify maintenance. That is trying to shift the burden from the appellant to the appellee. The wife, in this case, as the appellee, had no burden, didn't have to prove anything. The court didn't even have to take the offer of proof, which the court did. And so I don't see how it could be manifestly arbitrary, unreasonable, or unfair when there was no evidence before the court that there was a substantial and continuing change of circumstance to deny. I think the trial court was left with nothing else to do. That's all the trial court could do was dismiss the motion. As to the continuance, I think some of your questions, Judge Furman, kind of go to my argument in this regard, and that is, was there even a motion filed? There's an email that you can't read who it was sent to. There was no written motion for a continuance, and so I don't think that issue was preserved. Also, even if it was preserved, I don't think that, as pled by husband, that there was any unforeseen or exceptional circumstances. It cannot be unforeseen when you already knew on January 5th that you had a problem showing up for a hearing, that you do nothing until the evening of January 10th to try to secure a continuance. There is no reason why you couldn't have done that, so I definitely do not think that's an abuse of discretion. I don't think it's manifestly arbitrary, unreasonable, or unfair.
Well, he's saying it started to snow.
That was the additional thing, but it wasn't just that it snowed, it was all these other reasons that he'd already raised on January 5th, as I recall. And then there's some question of, is there snow in Wyoming, is there snow in Utah? Both of those are referenced at different times. Getting to the VA disability benefits, I just see that as a separate issue. Again, I don't believe that was preserved. I don't think by simply filing a motion to modify that you preserve an issue, a very unique argument that VA disability benefits cannot be used for purposes of income, to be considered income for purposes of paying maintenance or a source of funds to satisfy a maintenance obligation. I think this court has resolved that very issue in re the Marriage of Nobel. And I also think that the United States Supreme Court has addressed that issue in Rose versus Rose, and I cited both of those in my brief. There's some argument going back to the motion to modify maintenance that the court used an improper standard. I think I've addressed that as well as I can address it. There was no proof of a substantial and continuing change of circumstances, so that left the court with the court had no evidence before it to make that finding, so it didn't make that finding. I don't think it used an improper legal standard, and certainly didn't err when there was no evidence.
Is that a part of that new motion that you referred to earlier that's been held in abeyance?
No, I don't believe that is. I don't believe that either one of the motions, I know this one, the one that is on appeal here, did not. I'm fairly certain the subsequent one, but I didn't look at that, so I'm not positive about that. Okay. And certainly that can be an issue that can be addressed once that motion is resolved and can be resolved on appeal or what have you. I think I've addressed the attorney's fees as much as I want, and so unless the court has any other questions, I don't have much else to say.
All right, thank you very much.
Thank you.
All right, Ms. Aiken, you have just under a minute left.
I think it was 52, but that's okay. Your Honors, as far as the January 5th, I'd like to point out page 260 of the record. There's a minute order, and page 259 of the record, there is also a minute order. Both of those are on January 5th. It says in there that wife had flown out. She's able to prepare by phone for the recontinuance. And also in the other minute order, it says there's no confirmation that there was receipt, that husband had actually received notice that it had been rescheduled. And I'd also like to point out to the court page 304 to 09 of the record, which deals with the continuance, and his ADA request was made on January 9th. And then in his email to the court on January 10th, he indicates that he just did not know that he had a lawyer, and he thought that his lawyer was there for the January 5th hearing, and then he was trying to get home from Utah. So if the court would look at that, it would offer some advice. Thank you, Your Honors.
Thank you very much. Thank you, counsel, for your very helpful arguments. The case will now stand submitted, and we will be issuing an opinion in due course. That does end our docket for this morning, so the bailiff may announce a recess. Thank you. The court will be in recess subject